May it please the court. I am Rick Sikta, and I represent the appellant, Mr. Martin. And we are here on one, I believe it will be one issue today, and that is a juror misconduct issue that occurs in post-conviction that could not have been discovered by due diligence by any of the parties. And in this case, during Mr. Martin's post-conviction proceedings, it was discovered that one of the jurors that served in this capital case was adjudicated delinquent for a sexual battery when he was 17 for a girl or a child that was under 12.
How was that discovered during the post-conviction proceedings? So when the counsel received the prosecutor's file?
No, sir. To give you a brief procedural history, Justice Labarga, defense counsel discovered that the juror concealed a DUI charge. I filed the 3850 based on that. I then filed a motion to interview the juror, which was granted by the trial court. Right before that deposition, the state attorney's office provided that adjudication to us. If you know, the prosecutor in this case, we are not entitled to that as defense attorneys. Juvenile records are sealed. I'm sure the justices understand that. When we took the deposition, after much questions by myself to the juror, I asked him if there was anything else that he was holding back. He said that he essentially was a victim where his grandfather was murdered by his grandmother, and he admitted it was a gruesome crime. I think the record's clear. The juror was emotional during this deposition. I made it a point to put it in the record so this court would understand. And he said he was still emotional to this day. And that crime occurred in 1977 or 78.
Counsel, let me ask you something a little more fundamental.
Yes, sir.
As I understand it, the nature of your claim is a direct claim. In other words, it isn't an ineffective assistance of counsel claim with regard to this. It is a direct claim that the juror engaged in misconduct by not disclosing certain things that were required to be disclosed based on the questioning of voir dire. Is that a fair representation of the claim?
That's a fair representation under newly discovered evidence, sir.
So is it newly discovered evidence? In other words, is the claim a newly discovered evidence claim, or is it a standalone juror misconduct claim? Because that's what I'm having a hard time understanding.
That's a great question. We framed it under newly discovered evidence, and if you look at the case law, especially McDonough from the United States Supreme Court in 1984,
we're going to get there. But
yeah, yes, sir.
I just talk to me about the nature of the claim first.
We framed it as a newly discovered evidence claim, as well as an ineffective assistance of counsel claim just for the DUI. We thought that defense counsel should have been able to discover the DUI.
So you would agree, though, at least as the ineffective assistance of counsel claim, our case law requires actual bias?
Under Caratelli, I would say yes.
Okay. So the question is under the newly discovered evidence claim?
That's correct.
Okay. As to that, you're saying that Jones does not apply?
No, it does not.
Why?
Because of the litany of cases that have discussed De La Rosa in these procedural contexts. And, Your Honor...
But are those newly discovered evidence claims? I mean, De La Rosa itself is a new trial motion. Many of these come in the direct appeal context.
Correct. Many also come under the 3850 context, and I'll cite to you, Judge.
But are they characterized as newly discovered evidence claims or as standalone juror misconduct claims?
Farina was characterized as a newly discovered evidence claim. That came out in 2016. Right. Foster was argued under Brady and Giglow. Giglow, of course, couldn't have been discovered at trial. Johnston was using De La Rosa for an ineffective assistance of counsel claim under a motion for new trial. Lugo was a 3850 claim in the Florida Supreme Court in 2008. Also, Buenoano, a 3850 from 1998.
But again, that doesn't answer quite the question that I have. But let's operate under newly discovered evidence. So the newly discovered evidence isn't an independent claim. It's merely a way to get you around some procedural and time bars, correct?
Correct.
Okay. In other words, that's an exception to it needs to be filed within 2 years or some other things that are out there. The underlying claim itself has to be something that 3850 would litigate. Is that fair?
That's fair.
Okay. What does 3850 litigate? What are we trying to do in 3850? What rights are we vindicating?
Trying to vindicate fair and impartial trial and a denial of fundamental rights, or essentially if the Sixth Amendment and the 14th Amendment.
It's constitutional rights.
It's constitutional rights.
And it says that in 3850 itself. It has to be, we're here a violation of the Constitution and laws of the United States or the state of Florida, correct?
Correct.
Okay. So let's go to McDonough now. McDonough, well, let me ask you this. Is McDonough, I'll even back up there. Under federal law, is one entitled to a peremptory challenge? Does the federal Constitution require that states have peremptory challenges?
I don't believe so, sir.
Right, so it's not a constitutional right.
Correct.
McDonough itself, does McDonough rely on any constitutional amendment or rule of law?
McDonough is a very short opinion.
It is.
And
What does it cite to?
I thought it cited to the 6th. Don't quote me on that, Judge. I need to go back and look at the opinion.
Why don't you go, when you do sit down, I want you to
Yes,
go
sir.
look, but I read it fairly recently.
Yes.
And it seems to me that while it mentions a fair trial,
Right.
what it does talk about is a federal statute which governs certain things and a rule of, I think in that case, civil procedure that governs jury selection. Is that correct?
Correct.
Okay. Given that history, how could we, again, what right do we seem to be vindicating here if federal law doesn't require peremptory challenges, if McDonough, the case that we're relying on, isn't a rule of constitutional, doesn't set a constitutional rule, but instead interprets federal rules and statutes, such that whatever new evidence we have here, how is it directed at something that a collateral attack could give you relief on?
Doesn't necessarily need to be a federal right that we're vindicating, right?
That's agreed. So as a matter of state law, you rely on McDonough, a matter of state law, we seem to have set the test at actual bias, correct?
Under Caratelli for ineffective assistance of counsel claims.
Well, we've applied it in Boyd in other contexts, haven't we?
Boyd, yes, but that was a very different scenario, and I think the federal court in Boyd answers your question for me.
Well, but I'm not sure it does. I know the district court judge there tried to answer the question there, and he certainly made assumptions that this was a matter of federal constitutional law and that there are differences between how we correctly applied federal constitutional law. But that's why I started the questioning where I did. Where in McDonough does it set any constitutional standard, and where is there any constitutional standard for how peremptory challenges need to be conducted, other than it needs to not be obviously based on race or gender issues?
Under McDonough, it does not, Judge.
So
but McDonough floats.
So I have a hard time understanding how the federal district court has any right to criticize the way we have interpreted federal law or state law when there doesn't seem to be any federal law for which that is applicable in the collateral context.
If I'm not mistaken, I believe the federal court, and I'm not speaking for the federal court judge, obviously, but I need to bring it up to the court's attention because it found that this court erred and it was an unreasonable decision contrary to federal law. And I believe it cited the Sixth Amendment juror misconduct issue.
It did.
So I believe that's what the case is going on. And I think it's important under Boyd, and that's my argument here, and it always has been, is Caratelli is a very fact-specific case. It deals with ineffective assistance of counsel to failing to cause challenges. We have a completely different scenario here.
Well, you have a different scenario because of the claim, but I guess I understand litigating under ineffective assistance because that is a constitutional right. So that makes sense to me because that does implicate the Sixth Amendment. But once you take it out of that context, it's harder for me to understand how we're to apply some federal standard that based on a federal statute and a federal constitutional rule that doesn't seem to have any application to what we do here in Florida. I'm having trouble understanding how one, it must be applied as a matter of constitutional law to the other, such that we have to vacate a conviction.
Well, under De La Rosa, I mean, that's what this court has been using, the 95 opinion.
Right, but that's under a direct appeal in a different context. But when you take it in a collateral context, I'm having trouble understanding how as a matter of federal law, we are bound and required. Now, it may be under our own case law we're required to apply De La Rosa, and I want to hear that argument. But I'm having trouble understanding your claim that McDonough requires, as a matter of federal law, that the federal Constitution requires that we vacate without an actual bias finding.
I believe it's still the Sixth Amendment juror misconduct issue. He's entitled to a fair and impartial trial, and although the court's not coming out and saying you are constitutionally entitled to a peremptory challenge, they're saying that it renders peremptory challenges and procedural due process issues hollow if you don't.
But if the trial court has an evidentiary hearing where there's a finding at the evidentiary hearing that this juror was unfair, that these things did happen to the juror, but they did not affect in any way the juror's deliberations, and in fact the juror testified to that. And in fact, there appears to be a good faith reason why the juror answered as he did. He said he couldn't hear certain of the questions, and the trial court credits that. How is there unfairness? How is there unfairness in the trial, in the general sense?
Well, may I point out the credibility issue? It looked in the order from the 30 to 50, the trial court only mentioned the juror's credibility issue as to the DUI, and it did not cover the credibility issue to the other one. And also to that point, the trial court leaves out that there were numerous questions asked to this panel, 4 different rows of people being asked the exact same question. So he heard this over and over and over again, and the responses. And what's interesting that the court did not mention, Justice Luck, is in that deposition, the juror still concealed the fact that his uncle was involved in that murder of his grandfather. When the deposition was over with, we went back to our firm and looked up, I got the name of the victim, and we looked it up, and the uncle was also involved, and then we asked him at the evidentiary hearing, why did you fail to disclose this? Well, it's still emotional, and my uncle told me on his deathbed that he wasn't involved. I mean, that's not a very genuine answer to conceal that.
He said he testified that his uncle professed his innocence, and so that he was not going to allege that his uncle was involved.
He professed his innocence, but does somebody, we just listened to the last case. If somebody tells you something, does that mean you not conceal it when he has an adjudication and went to prison for it? I think that would be the issue, Justice.
Can I ask you just kind of a more mundane question?
Yes, sir.
You start your brief talking about the 1-year deadline. If the whole thing that led you down the path of discovering this information was the DUI arrest, which then caused you to file the motion to interview, et cetera, why couldn't that have happened within the year?
The DUI?
No, why couldn't you have discovered this within the year deadline?
The
You could have, the DUI, the thing that caused you to go down this path was something that was a matter of public record that clearly with diligence you could have uncovered within the first year, filed your motion for the interview, et cetera, et cetera.
We did. The DUI issue was filed within the time limit, Justice. That was framed as that was framed as an ineffective assistance of counsel claim. So when that claim, we did not know about any other jurors' issues because we literally could not find out. The state concedes
But you could have but the interview didn't happen. You didn't attempt to interview the juror within the first year.
We cannot, under Florida law, we cannot interview without filing a motion.
But you didn't do that. You didn't file the motion within the first year.
What happened, Justice, is we filed the ineffective assistance of claim, and then, as you know, we have to wait until the trial court grants the evidentiary hearing in this issue. The trial court summarily denied all of our claims except for the death penalty case under Hurst. I filed a motion for rehearing. The judge granted our juror DUI issue, and that's when we had the evidentiary hearing. I filed the motion to depose because we knew we were going to have to essentially either put the juror up on the stand or get to depose him to find out what he's going to say on the stand. The judge granted that motion, and that's when the state provided us with that material. We could have not found out that material without the state originally giving it to us when the deposition was, I think it was 5 days before the deposition, they gave us that material about the sexual battery.
No, I understand
Yes,
that part. Okay.
And so it was impossible. And the grandfather and grandmother's name is different than the juror's name. That wasn't going to come out unless he disclosed it. And I think the trial court's order and the state concede that with due diligence, those two issues would not have been discovered by defense counsel and by the state, for that matter, the juror murder, the homicide murder with his grandmother and grandfather and uncle. So back to Justice Luck, De La Rosa has to apply here. The court's prior opinions apply De La Rosa. Now, if you look at, and there was a first DCA case under Mitchell, which they used kind of a variation of De La Rosa because De La Rosa came out in 1995, and Mitchell from the first DCA was a 1985 case. They were banking on what I assume was the McDonough opinion, and they went over in a context that you have to prove juror concealment, you have to prove the defense counsel was duly diligent, and you have to prove that the information was relevant material. And they granted a new trial, and the state's not contending, at least I think, that we meet all of those elements. And I think that's the problem here is like, why is this so easy? Justice, because under De La Rosa, we do meet those elements. This is relevant material all day long because the juror is still emotionally scarred and he's the victim of a murder, and now he's going to be asked to be fair and impartial to another homicide case where there was also a gruesome death. And that
What should we make of the fact, though, that when you guys had the opportunity to, at this hearing, to talk with counsel, even though you kept trying to get him to say that he would have used the peremptory challenge on this juror, the lawyer kept going back to the dishonesty issue, but obviously the question is, if the questions had been answered correctly and, what would the lawyer have done? And despite you repeatedly trying to get him to say that he would strike the juror, he never did.
He said he would have struck the juror for cause.
On the dishonesty.
On the dishonesty.
Which isn't the issue. The issue is if you had answered it truthfully.
Yes,
right?
sir, you're right. But also he mentioned that because of the juror's emotion and the sympathy that he would have had for the victim. If you also read that, that's also layered in there as.
But he never sort of closed the loop. He never said that he would.
Defense counsel.
He was an interesting character. I know. We read it, but he never gave the answer that you wanted him to give.
I think he did. I think with those, he just didn't say it clear enough. And he mentioned and you could see the little banter he had with the prosecutor about whether the juror was deceiving when he heard all of these questions, and that the juror didn't hear the questions, even though they were asked several times.
Counsel, you are now in your rebuttal time. You may continue, or
I will wait. Thank you, Justice.
May it please the Court, Assistant Attorney General Charmaine Millsaps representing the state. First, I would like to talk about whether this was discoverable. Your Honor, both prior litigation and jurors' prior convictions are discoverable at trial. It is very easy. This trial was in 2009, but
you admit or you agree that juvenile records are sealed. That means
absolutely. My argument is going to be limited to the DUI conviction. I conceded, as I did down below, that both the juvenile records and the grandfather's murder nobody could find those. But the DUI conviction, attorneys can find that at trial. All you have to do is run backgrounds on the juries. Your Honor, those issues should be required to be not just raised on a direct appeal.
That was filed within a year, and they filed it as an ineffective assistance claim, so I'm understanding.
And as an ineffective assistance,
Right.
I'm more than willing. But in terms of discoverable, a trial attorney, defense attorney Quentin Till, could have run a background check on these jurors.
It sounds like you agree that there was ineffective assistance.
No, I'm saying there's not. I think they don't run them for a reason. I think it's strategic. So first of all, I think ineffectiveness, you need both deficient performance and prejudice. So yes, if you do it that way. But these are discoverable way before a year. You can do it during trial. I also would like to directly tell you that the trial judge found that he would not have used a peremptory defense counsel because he did not strike another juror who did have a DUI conviction. So I've got a finding from a trial court that he would not have stricken based on the DUI conviction.
But the DUI conviction, from a trial lawyer standpoint, the main one, from what I see here, is the fact that his grandfather had been murdered, and he was emotional about it. And here you are dealing with the same type of issue in this particular case. That will be the one that I would think a trial lawyer, had he or she known about it, may have raised some concerns. It may have caused a peremptory challenge, at the very least a challenge for cause, if denied a peremptory challenge. And that, as you have just admitted, was not discoverable unless the juror actually came out and told everybody. There's no way he could have known that.
No, and so he can't be deficient.
Because you're sticking to the DWI case.
But
people sit on jurors with DWI cases, convictions all the time.
Exactly, Your Honor.
Well.
So the DUI part, to me, there's no ineffectiveness. The standard is ineffective assistance to counsel.
But that's
you
not
may not raise a newly discovered De La Rosa.
Why?
Because, Your Honor, newly discovered evidence is an exception to even the one-year time bar. You can raise newly discovered evidence claims 20 years later. And we limit that to one thing. There is one test for newly discovered evidence, that's Jones. It must go to the guilt and innocence of the defendant.
Except that we seem to have done it in this context many times.
Well, but Your Honor, no, and I cited 6 cases where you applied Caratelli. I openly admit you seem to be you were at one point, the court was doing both. But this court's recent case law is applying Caratelli and Caratelli only. And I cited
let me ask you this.
7 cases.
Let me ask you this. Has this court ever applied a De La Rosa non-actual bias standard to evaluate a claim like this one?
Yes.
Okay. So we would have to recede from those cases.
Well, but Your Honor, sometimes you did it sort of in the alternative. You would do Caratelli, and then in the alternative you would do De La Rosa. So you weren't, I don't think you will have to recede from those cases. A lot of those cases were just in the alternative.
Well, let me ask you this. If we were to apply De La Rosa, would the state lose in this case?
The trial court found that it was not material.
Why?
Because the trial court believed the defendant when he found that this defendant was not actually biased. And he believed him when he said
that goes to actual bias, but as to the materiality question isn't whether it affects the juror, it's whether the attorney would have exercised a peremptory challenge based on that information. Is there evidence in the record to support that the attorney would not have exercised a peremptory challenge if he had known about the DUI, about the juvenile sexual battery conviction, and about the murder of the grandfather?
I'll have to do them one at a time. Yes, there is evidence in the record regarding the DUI. There was another juror who sat, and he did not strike him.
Okay.
The juvenile conviction, if anything, remember what this defendant said. He had a little ill will against the state. That's not, Your Honor, it's not actual bias. It's actual bias against the defendant.
And what about what about being the victim of a murder?
Well, to me, that was so long ago. He said it didn't affect his. We never specifically ask about the grandfather. If you're asking me, the trial court found he was not actual bias on that either. Because of the
time from when it happened to the time of the trial?
And how old the defendant was. Your Honor, we're not even sure when this crime occurred. It was the late 70s. He seems to have been 10 or under. What he heard was hearsay. He directly testified multiple times that it did not affect his verdict at all.
So even if
once again, Your Honor, it seems like it was a plea, and what he was upset about was that his grandmother only spent 5 years in jail. And if it was a result of a plea, that's the state again. Your Honor, every one of these boils down to, I don't think there was any bias, just like the trial court.
So even if we were to apply De La Rosa in this case, you think that we still would reject the claim? Or we would affirm the rejection of the claim?
Well, you would not find actual bias. Your Honor, De La Rosa needs to be limited to not just direct appeals, but objection. You should even do McDonough on post-trial motions, or actual bias. I'm not going to call it McDonough power, but actual bias should be the standard.
That's why, since McDonough doesn't say anything about actual bias in it.
Okay, but Your Honor, as long as we're talking about constitutional injuries, the only constitutional limit on these kind of allegations that I know of is Pena-Rodriguez versus Colorado, and they're limited to allegations that jurors engaged in racial bias. That's the constitutional limit here. So constitutionally, the only issue would be what the United States Supreme Court requires to punch a hole in Lord Mansfield's rule. Constitutionally, when the allegation is racial bias. Here, the defendant was white, the victim was white, the juror in question is white. There's no allegation of racial bias. So constitutionally, Pena-Rodriguez does not apply, and we're really done with that. That's the only constitutional limit that I know that the United States Supreme Court has said states must do. Pena-Rodriguez involved Colorado. And they had the equivalent, they even called theirs 606B. And they said, and the United States Supreme Court held that because it was an allegation of racial bias, it must be explored and you must consider it. And that's the only constitutional limit. So if we're going to talk about the Constitution, there's no doubt that this claim wouldn't even necessarily have to be explored under the Constitution, because it's not a racial allegation by a bias. That's the only limit I know constitutionally. It's Pinheiro-Rodriguez versus Colorado. Okay, so De La Rosa should be limited to literally when you object. You should have to object both prior litigation, which is what most De La Rosa things are based on, and a juror's criminal history are readily available. You should have to object at trial contemporaneously, and by contemporaneously I mean before the jury goes back for deliberations. You have the entire trial to run something that takes less than an hour to run. Both of those should have to be brought before the court, and De La Rosa should only be raised as the judge, after I brought it to his attention, did not send the alternate back. Everything else under Rule 3.575 and Civil 1.530B should be extraneous, things that are difficult to find, racial allegations, that kind of thing. Those should be the kind that should be post-trial. You should have to preserve the De La Rosa claim. Those things are just too easy to find these days, Your Honor, both prior litigation and criminal history. Oh, I would like to talk about Boyd in this sense. Your Honor, the district court's order really talks about 2 jurors, and so did this court. One of the jurors, Juror Striggles, had numerous prior felonies, but there was another juror, Juror Reebstock, that had misdemeanor, prior misdemeanor not disclosed. The federal district court, regarding that juror, who's much more equivalent to here, did not have an evidentiary hearing regarding that, found the claim to be without merit, denied habeas on the juror who had the misdemeanor conviction, and did not even grant COA on that issue. We are much closer to the misdemeanor juror than the felony juror at issue in Boyd.
But as I understand the criticism of the district court judge, it was the trial court finding no actual bias without conducting an evidentiary hearing below. That was what the district court was concerned about, that the trial court, based solely on the record before it, made a finding of, and us too, made a finding of no actual bias, applied that as the standard, and yet there was no evidentiary hearing to support that. But we have an evidentiary hearing here.
Yes, you did have an evidentiary.
And the trial court found no actual bias.
Yes, we do have an evidentiary hearing.
So even taking Boyd on its face that somehow McDonough sets a constitutional rule that must be applied, that was incorrectly applied by us, here there was a hearing, there was a finding of no actual bias, and we're outside that critique.
And that's with a juror who was statutorily disqualified. The federal district judge did not do that on the misdemeanor juror. There was no evidentiary hearing. There's never been an evidentiary hearing on the misdemeanor juror at issue in Boyd, Juror Reebstock. He didn't even, because what federal district court held is that's not a basis for a cause challenge, so that just doesn't matter. There's no evidentiary hearing held on the second misdemeanor juror, and we're a lot more. This case is more like the second juror. There are no felonies involved here.
And there's no claim here that the juror is statutorily ineligible. In other words, that wasn't the claim that's brought here, that a statutorily ineligible juror served. The claim here is, had I known this information, had he not lied, I would have struck him with my peremptory challenge. Not that I was deprived of my cause challenge, right?
Exactly.
Which is a very different claim.
Very different claim. And the district court, the federal district court itself, was dealing with 2 different jurors and did not hold an evidentiary hearing on that second juror, Your Honor. And this is a misdemeanor, a 17-year-old misdemeanor, and the juvenile adjudication was even older than that. The juvenile adjudication was approximately 24 years before this trial. And I'm talking before the trial. So now, Your Honor, obviously we're going to try to get Boyd straight and the Caratelli standard straight up in the 11th Circuit, because our position is the 11th Circuit does the exact same thing of having a higher standard. Both the United States Supreme Court, the 11th Circuit, for example, Purvis versus Crosby, which I supplemented with, was cited in Caratelli twice. Judge Carnes wrote Purvis, creating a higher standard, really regarding the prejudice prong of ineffectiveness, both because of finality and because of procedural bars. The Caratelli court, citing Purvis for some other things, but clearly aware of Purvis, citing it twice, also adopts a higher standard for post-conviction. Years later, the United States Supreme Court in Weaver versus Massachusetts does the exact same thing, both due to interests about finality and interests about procedural bars. Your Honor, what you're really going to do here, if you recognize newly discovered evidence of De La Rosa, I realize this is an initial post-conviction, but newly discovered evidence is usually raised in the context of successive decades after the trial. And so if you have newly discovered evidence of De La Rosa, what you're really saying is that you can litigate jurors 20 and 30 years after the trial. So the problem with creating newly discovered evidence is it's an exception to everything. It's an exception to time bars. It's an exception to procedural bars. And it's fine to do that, Your Honor, but we do it in one context and one context only. And that's either innocence of crime or innocence of penalty. And that's why we require it weaken the case against the defendant or against the penalty. Okay, so if you have newly discovered evidence that relates to the case and the strength against the defendant, may you bring that 20 years later without any time bars? Yes, you may under newly discovered evidence. But because newly discovered evidence, we're doing that because we want innocence, claims of innocence or innocence of the death penalty. And we listen to them 20 and 30 years later. But you should not. De La Rosa shouldn't even be the standard in post-conviction. I don't even think it should be the standard one. You should have to preserve that at trial. It shouldn't even be the standard on direct appeal, if not preserved. But if you move to post-conviction, this needs to be limited to ineffective assistance of counsel. Newly discovered evidence claims need to be limited to the evidence against the defendant regarding either his guilt or his sentence. And so, but I would like to end with the juror did repeatedly testify that none of this, he held none of this against the defendant. And the state doesn't believe there was any actual bias, but if there was, it's very clear that the juror held ill will against the state, not the defendant. Actual bias must be against the defendant, Your Honor. And so, yes, it is Caratelli that applies. Does the state urge you to clarify that for the exact reasons given in Caratelli, given by the 11th Circuit in their case law, given by the United States Supreme Court in their case law, that because this is post-conviction, you must raise this as an ineffective assistance of counsel claim, and Caratelli does govern? Yes, we do urge you to clarify that. And if there are no further questions, we ask that you affirm the trial court's denial of post-conviction relief. And thank you for your time.
I think justices of this court recognize the fatal flaw in that argument. The state mentioned it 3 times. The De La Rosa should preserve a De La Rosa issue at trial, or the ineffective assistance of counsel claim should control. But how can one be ineffective if they did not know of these disclosures? Defense counsel cannot find out about the murder, and defense counsel can't find out about the rape conviction. So how can Caratelli possibly apply to a factual scenario like this when it was literally impossible and conceded by all of the parties that this could not have been discovered until post-conviction? And more importantly, until the juror disclosed it in post-conviction.
But counsel, I think it's the part of Caratelli that requires actual bias. In other words, if we're going to make it's similar to direct appeals, but if we're going to reverse and use our collateral powers to vacate a conviction, that there should show some effect on the jury. I think that's the thought process behind this. And why should that principle, which applies throughout many other jury issues by this court, including on inappropriate inappropriate seating of jurors, failure to strike for cause when should have stricken for cause. Why should that not apply in this context?
Because McDonough and De La Rosa and the cases that used McDonough and De La Rosa from this court say we have to apply it this way. And you, Justice Luck, you brought up...
As a general rule, do you agree that finality becomes more important the further away you are from the trial? Because witnesses are gone, you can't necessarily retry a case, so finality becomes more important the further away from your trial. You agree with that, correct?
I'm an advocate of finality.
What's that?
I'm an advocate of finality myself, much to people's different opinion, but problems arise when, we've seen it in wrongful convictions cases, we see it in DNA cases, especially in capital cases. We need to have an opportunity to litigate an issue like
but
this.
Why would you have a standard that didn't require you to show that it actually made a difference, an actual bias or similar standard, when you're talking about claims that can be brought, as Ms. Millsap said, not just 2 years later, but 10 years or 11 years, newly discovered evidence? I mean, it just, the finality component would seem to compel a standard that requires that you at least show that it made a difference. And I don't know why that wouldn't be true.
That's a good point, Justice. I think my answer has to be that finality takes second chair to the defendant's Sixth Amendment rights to have a fair and impartial trial.
But there's no Sixth Amendment right to a peremptory challenge.
Correct.
Okay,
I believe there's a Sixth Amendment right to the jury misconduct that occurred. That would be the argument that we put in the brief, and that would rely on the cases from the Florida Supreme Court and Boyd's interpretation. I understand Justice Luck's argument to that of the Sixth Amendment issue. It renders hollow these peremptory challenges and cause challenges when you allow a jury to be on here because he intentionally or not intentionally, I would argue intentionally based on my prior arguments, concealed some very damning issues about himself, to pardon my language. And then if you read his evidentiary hearing testimony, he also mentions, well, I didn't believe Mr. Martin when he got on the stand and testified. Ironically enough, his grandmother posed a self-defense case to her murder of his grandfather that was found to be wrong or frivolous or false as well. So it's very interesting dichotomy when you're trying to say that all of these things somehow don't mean anything because the juror gave him a fair trial. And I still think actual bias applies given all of the things that happened and the juror's continued deception well into post-conviction. To me, and without doing the research, we would have never known about the uncle. I mean,
Counsel, your time is now expired. You can take another 30
sir.
seconds or so to sum up if you'd like.
Justice of this court, I would argue that the standard is clear. Newly discovered evidence has to apply in this case because defense counsel could not have found out about this, so he cannot be ineffective, rendering Caratelli outside the window of this review. And I would ask, based on the simple three prongs of De La Rosa, that we clearly meet it. Justice Luck asked the state to rebut that. I did not hear any answer because it's material, it was concealed, and defense counsel said that he would challenge for cause and peremptories, and I would ask to reverse for a new trial. Thank you.
We thank you both for your arguments. The court will now stand in recess for about 10 minutes.
All rise.